Hello, I'm Carol Tello, an international tax partner in the Washington, D.C. office. I'm joined by Lauren Stewart, an associate also based in the Washington, D.C. office. The new tax law has made significant international tax changes. We will provide an overview of the provisions that affect both U.S. and foreign-parented multinational corporations.
The big headline for corporations is the reduced corporate tax rate from 35% to 21%. The lower 21% rate is designed to make the U.S. more competitive with international rates. For example, Ireland has a rate of 12.5%, and the United Kingdom has a 20% rate currently, which will decrease 1% per year until the UK rate reaches 17% in year 2020. The reduced corporate rate is meant to prevent inversions of U.S. companies and to encourage foreign investment in the United States.
Although much has been written about the U.S. shifting to a territorial regime, what we actually ended up with is a hybrid territorial/worldwide system. Now, instead of having Subpart F and deferred active income that was subject to U.S. tax only when the active income was repatriated to the U.S., now we have three buckets of foreign income: Subpart F, GILTI, or global intangible low-taxed income, and any income not characterized as Subpart F or GILTI. That latter default bucket may be repatriated tax-free to the U.S. by 100% dividends received deduction. As a result, the U.S. shareholder pays no tax on any foreign source portion of a dividend from a foreign subsidiary. GILTI essentially is a minimum tax to prevent profits of U.S. companies to remain untaxed in a low or no tax jurisdiction. Such untaxed profits likely led to the EU Commission state aid cases. GILTI's twin, FDII, is the opposite and provides a preferential rate for foreign-derived intangible income similar to the EU's patent box, except that no nexus requirements are imposed.
Subpart F generally subjects U.S. shareholders of controlled foreign corporations, or CFCs, to U.S. tax on the CFC's passive and mobile income. The new tax law provides two significant changes that will increase the number of CFCs. The U.S. shareholder definition has been broadened to include a person who owns 10% by voting power or value. The second change is the elimination of the 30-day exception. Prior law excluded CFCs that were owned for 30 days or less from the definition of a CFC. Under the new law, a foreign corporation becomes a CFC on the date of acquisition, assuming that the ownership test is met.
Significant new base erosion provisions were added by the new tax law, which brings the U.S. more in line with other OECD countries. These provisions are the AntiHybrid provisions found in new sections 267 Cap A and 245 Cap A, the BEAT, and a limitation on deductible interest payments, whether paid to a related or unrelated party. Additionally, there are new limitations on intangible property transfers.
The AntiHybrid provisions are designed to eliminate the ability of a taxpayer to arbitrage different treatment of payments or entities between two jurisdictions. Essentially, the provisions prohibit a deduction for such payments where the payment would not otherwise be subject to tax in either jurisdiction. The interest deduction limitation applies to both related and unrelated parties.
The base erosion anti-abuse tax, or BEAT, applies to most payments made by a U.S. person to a related foreign party at a 10% rate. Even interest payments that are subject to the interest deduction limitation may also be subject to the BEAT. Finally, new limitations on intangible property transfers will impact U.S. companies. Those provisions expand the definition of intangible property to include goodwill, going concern value, and workforce in place. Significantly, the Section 367 active trader business exception has been repealed. Other changes have been made that will affect the valuation of IP and transfer pricing methodology.
Thank you for viewing this video on international tax provisions. For more information and other bottom line videos, please visit eversheds-sutherland.com. Thank you.
Thank you.